Welcome once again to Lehto's Law. Here's Steve Lehto.
I've had quite a few people ask me about the case that's before the U.S. Supreme Court right now about some states put their laws online behind a paywall. And the question is, should you really have to pay to see what the laws are in your state? And I think in general that principle is ridiculous. But, of course, there are people out there who say, well, no, it makes complete sense. So, here's the deal. I point out often that the blue books behind me are the law books of Michigan, the Michigan compiled laws. Those are actually published by a private publishing company. So if you want to buy a copy of a set of the laws of Michigan, you contact West Publication, at least that's who put that set out, and you spend some money and you buy the books. Now, you can go online in the Michigan State, the government website for the state of Michigan has our laws online. You can just search them and you can look stuff up. So if I tell you that, Michigan's lemon law is MCL 257.1401 at sec, you can type that into the search engine. It'll pop up and you can actually go to the website. You can see it, read it, see when it was adopted, see when it's been amended, and then scroll through the different sections of the law. It's online. And I believe that the laws should be available to the citizens of the country because we always tell you ignorance of the law is no excuse. But if you can't find out what the law is, it almost would become an excuse. So what's going on right now is a situation before the Supreme Court involving Georgia. And I get the story here from Bloomberg Law, but it's been reported widely in other places. And Robert sent me this link, but I've seen it in other places, like I said. And so Justice Neil Gorsuch asked during the questioning on this, the oral arguments, why would we allow the official law to be hidden behind a paywall? And what we're talking about now is technically it's a copyright scheme that some states have. So that question posed to Georgia's lawyer at the U.S. Supreme Court just a couple days ago is a dispute over the state's abilities to copyright their legal code. And there is a slight distinction. I want to make sure it's very clear here. It's the legal code versus the annotated legal code. So Michigan's lemon law will say, here's what the law is, and the law is the actual words of the statute passed by the legislature. Well, there are organizations out there, companies out there that will read the law and then annotate the law, where they'll actually have people who know what they're talking about write things and say, well, here's what this law is intended to do, and here's some other laws similar to it, and here are some cases that refer to the law and interpret the law. And those annotations are very, very helpful to attorneys. But I'll tell you right now, the blue books behind me do not have annotations in them. They are simply the printed versions of the law. So what Georgia has done is they've taken the law with the annotations provided by a third party out there and put those up on their website and said, if you want to see these, you have to pay to see them. And so a company out there thought that was unfair and simply started pulling the stuff off and publishing it so anybody could see it. And that's where the problem arose. So the case has consequences for access to and cost of legal materials. And, both sides are arguing about this. There's a whole wide group of people who've weighed in on this, from small town lawyers and small firm lawyers who say they can't afford access, to a coalition of states looking to uphold their existing business arrangements because they're making money off this. One attorney for a state said that you cannot blow up this situation because you'd be destroying not only Georgia's copyright regime, but similar ones in about a third of the states. So we expect that the Supreme Court will jump right on this and issue a ruling in about 6 months. But the copyright fight started with Georgia suing publicresource.org, a group that advocates for public access to the laws. Georgia's annotated laws are published by LexisNexis, a big group in this field, and they have an agreement with the state that gives LexisNexis exclusive publication rights, meaning that someone else cannot publish the laws of the state of Georgia, apparently. But Georgia claims the copyright and sued Public Resource for infringing on it because they tried to publish their own version, that is, Public Resource org did. So the real issue here, though, is the commentaries, the case notations, and editor notes, but those aren't the law. And again, here's the issue. If someone comes along and says, we want to simply publish the laws without the annotations, I think they should be able to do that all day long. The question is whether the states will let those people do that. Some of the justices jumped on the force of law point, that is regarding whether or not the commentaries, case notations, and editor notes are actual law, or are they stuff that's been added later that adds value that should be protectable by the state. Justice Ruth Bader Ginsburg asked one of the attorneys why it shouldn't matter that these annotations are in no sense the law. They're just useful information on how the law has been interpreted and applied by others. But the attorney that she asked the question of pointed out that the annotated legal code, when it's published by the state of Georgia, or at least on their website, bears the state's imprimatur, which is, in essence, the seal of approval in Latin. When the state is telling you this is a good summary of the statute of the case, you're going to treat that differently. And it's not for nothing, as the old saying goes. The U.S. Court of Appeals to the 11th Circuit ruled against Georgia in its decision. And that's why they're up on appeal now in the U.S. Supreme Court. One attorney argued that affirming that decision would be very disruptive for states, noting that about a third of them also claim copyright in annotations to codes put out by commercial publishers. So affirming the decision below would blow up those regimes. Meanwhile, the U.S. solicitors, the U.S. Solicitor General's office has sided with the state of Georgia in this. And again, like I said, the other stuff maybe, but the laws themselves should be available to anybody who wants them for free. Justice Brett Kavanaugh likewise pointed to the consequences of upending existing arrangements, highlighting what he called the state's very strong argument that this is going to create problems in terms of incentives for creating these annotations in the first place. Well, I don't care about the annotations. I really don't. I mean, if they're there, I'll look at them. But I'm just simply talking about the general concept that the law needs to be available to anybody who wants to search it. And it should be online. And that's one of the things I think that tax dollars would be well spent on if they can do it reasonably. And you take the entire Michigan code and put it online to where it's searchable. And when I'm talking to somebody, they say, Steve, what's the law on that? I go, here's the law. You can look it up yourself. And I remember a time when if you wanted to look up a law, you had to go walk, in my case, across the hall into a law library, or up to the local library and check the law books out there, or to the local courthouse and check out their law library. And actually go dig through books and look for stuff. Nowadays, the stuff can be at your fingertips, and it ought to be. So, again, I don't have a problem with them putting stuff behind a paywall that's proprietary. But by no means should the law itself be proprietary to anybody. The law, if it governs you, belongs to you. By the way, the law is also passed and created by people that you elected, okay? So the idea that you elect somebody to pass laws that govern you, but you got to pay to see those laws, that's insanity, my friends. So there you go. So the case right now has been argued in front of SCOTUS. SCOTUS will rule in about 6 months. And when they do, I'll let you know. Questions or comments, put them below, and let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I am putting myself to the fullest possible use, which is all I think any conscious entity can ever hope to do.